Hello everyone, welcome to Administrative Law Lecture. I'm Marjina Sultana, an assistant professor from Indraprastha Law College, Greater Noida. Today we are going to discuss a very important concept under administrative law, that is Ombudsman. The word Ombudsman is a Scandinavian word which means representative of the people. This concept of ombudsman at first originated in Sweden, a Scandinavian state, in 1809. This ombudsman is an officer of parliament, is a public official which they are appointed to investigate the complaints or the grievances of the citizens against the functioning of the government or the public official. So Garnier defines ombudsman as an officer of parliament having his primary function the duty of acting as an agent for parliament for the purposes of safeguarding the citizen against abuse or misuse of administrative power by the executive. So, an ombudsman is an officer of the parliament appointed by the government, usually appointed by the government or by the parliament or an organization, but their main purpose is to defend the rights of the citizens, to safeguard the interest of the public by by investigating and addressing complaints reported by the individual citizens. So, if you think the action of the government are unfair or are not sure whether the government department acted fairly and reasonably, then you can lodge a complaint against the concerned authority. And this ombudsman makes a neutral and investigation, an independent investigation, though they are appointed by the parliament or the executive or an organization. They are independent. They are an independent and an impartial body. In India, the concept of constitutional ombudsman was proposed by the then Law Minister Ashok Kumar Sen in the Parliament in the early 1960s. Ombudsman is more commonly known as the Lokpal or Lokayukta in India. This term, Lokpal or Lokayukta, was coined by the Dr. L.M. Singhvi. So they perform the function of an ombudsman and inquire into the allegations of corruption against certain public functionaries and for related matters. This Lokpal institution of Lokpal and the Lokayukta is important, is needed to check the corruption, and they are independent. This is also important because most of the anti-corruption agencies are hardly independent in India. Even Supreme Court has termed CBI as a caged parrot and its master's voice. Ombudsmen in India are also referred to as Chief Vigilance Officer or CVO. The Central Vigilance Commission was set up on the recommendation of Sanatanam Committee. Now let's understand ombudsman in various sectors. For example, electricity ombudsman, insurance ombudsman, banking ombudsman, income tax ombudsman, and anti-corruption ombudsman. The jurisdiction of Lokpal includes the Prime Minister, ministers, members of parliament, Group A, B, C, and D officers, and the officials of central government. Though the jurisdiction of Lokpal included the Prime Minister, they don't have jurisdiction over Prime Minister on allegations of corruption relating to international relations, security, the public order, atomic energy, and space. The Lokpal does not have jurisdiction also over ministers and the MPs in the matter of anything said in Parliament or vote given there. Its jurisdiction also includes any person who is or has been in charge of director, manager, secretary of any body or society set up by the Central Act or any other body financed or controlled by the central government and any other person involved in act of abetting, bribe giving or by bribe taking. The Local Act mandates that all public officials should furnish the assets and the liabilities of themselves as well as their respective dependents. Lokpal has the powers to superintendence over CBI and to give direction to CBI. If Lokpal has referred a case to CBI, the investigating officer in such a case cannot be transferred without the approval of Lokpal. The inquiry wing of the Lokpal has been vested with the powers of a civil court. Lokpal has powers of confiscation of assets, proceeds, receipts, and the benefits arisen or procured by means of corruption in special circumstances. It has the power to recommend transfer or suspension of public servant connected with the allegation of corruption. It has the power to give directions to prevent the destruction of records during the preliminary inquiry. The state level Lokayukta institution has developed gradually. Maharashtra was the first state to establish the institution in 1972, but Orissa was the first state to present a bill on establishment of Lokayukta in 1970. Other states also followed them. Bihar in 1974, Uttar Pradesh in 1977, Madhya Pradesh in 1981, Andhra Pradesh in 1983, Himachal Pradesh in 1983, Karnataka in 1984, Assam in 1986, Gujarat in 1988, Delhi in 1995, Punjab in 1996, Kerala in 1998, Chhattisgarh in 2002, Uttaranchal in 2002, West Bengal in 2003, and Haryana in 2004. With this, I'm concluding our discussion on Ombudsman, Lokpal, and the Lokayukta. Thank you for watching.